My name is Manali Manukian. I'm the Executive Director of the Center for Art Law. And again, thank you all so much for joining us. You will see on your screen, there is a little poll for you to fill out while I take the time to let you know a little bit about the center. We'd love to learn more about all of our wonderful audience members. For those of you that are unfamiliar with the Center for Art Law, we are a research and education organization that's dedicated to offering resources and programming for the advancement of a vibrant arts and law community worldwide. Through our website, newsletter, and events, we disseminate information and keep our audience updated on art law related news, programs, cases, publications, and more. The center facilitates conversations by hosting and participating in programs such as the one we're having today. And we also have a great internship program that allows students to get firsthand education and experience in the art and cultural heritage law world. The Center for Art Law is also proud to offer the Judith Bresler Fellowship in honor of the late Judith Bresler, a pillar of the art law community, to candidates who exhibit many of the gifts, qualities, and passions that Judith so beautifully embodied. Our fellow for this year actually just released her report on the progress that she's made so far. If you're interested in reading that, I've listed it into the chat. Feel free to take a read. We have one event coming up at the end of January that I'd be remiss to not tell you about. It was a discussion with Aaron Crowell and Irina Tarsis on fakes and forgeries and more. Think of it as an accompaniment to the famous film F is for Fakes. If you have the time, we would absolutely love to have you all join us there. A special welcome to all of our premium members that are present here today. The Center for Art Law couldn't be the success that it is without the support of other amazing art law fans in the community. If you're interested in discounted or free access to our events or access to past recordings and our case law corner, please consider signing up for our premium membership. Also, we invite you to just subscribe to our newsletter to receive updates and invitations to events like this, and visit our website at www.itsartlaw.org. Or if you can, make a donation to help us create more events like these. Before we begin, a few of the usual housekeeping items. In case you haven't noticed already, this program is currently being recorded for archival purposes. Feel free to turn off your camera if you're feeling uncomfortable. If not, we'd love to see your faces. And please remain muted to prevent any background noises from filtering through. If you have any questions during the event, feel free to throw them in the chat. We will be monitoring it as it goes on. It's the easiest and most seamless way for us to present these questions to our speakers. A link to the handout with bios and reading materials will be sent in the chat right as we begin. These will also be emailed to you right after the program, along with a brief survey. And we'd appreciate you letting us know what it is you think. Now let me introduce Irina Tarsis, the founder and managing director of the Center for Art Law, who will present the speakers and give us a little substantive overview of the topic. Irina, take it away.
Thank you, Nelly. Thank you so much. Welcome, everybody. I am delighted to be on the side of 2022, and I'm very grateful to our speakers for accepting our invitation and launching our Art Law talk series for the new year with the subject of art storage. So we have this format kind of embraced, I suppose. We have a non-lawyer in the audience or in the room who's going to tell us how the real world functions, and then we have a lawyer who will tell us how the same world functions with lawyers' role, making things more seamless. So to present the real world scenario, Simon Hornby is going to talk about the operations of this huge art storage entity called Crozier. He is the general manager and senior vice president of Crozier Europe. And then one of our wonderful advisors, Hanoch Sheps, will discuss the legal side of contracts that probably are very important in making things run smoothly. So to put you in the mindset to talk about art storage, and I'm very happy to see that we have a lot of guests who are attorneys, as well as many who are students and artists and non-attorneys interested in this subject, thinking about what do you do with the art when you run out of wall space, for example, or when the tastes change, or when the weather changes. where should these works of art go for safekeeping storage? So the places that we go at the Center for Art Law, they're very varied and far-flung. Here you can see a work of art traveling in style on public transportation. And I have to say the inspiration for this talk has been a number of events and lectures and publications that the center has done on art storage, a number of law cases that have been coming out of New York that I believe we'll discuss later, and attendance going to lots of galleries and museums and homes thinking, who can handle all of these works of art carefully, and what does it mean? Where do they go? And now that we're talking about digital art as well, there is a question of how does one store digital art? So I had a pleasure visiting Crozier here in Switzerland. And the reason I give you a picture of these gentlemen looking at works of art at the last Art Basel, they might be thinking, how will we schlep these pieces to our home, or where should they go when we are renovating? So the subject of, now that you have it, where are you gonna keep it is quite interesting for us. And I would like to turn the floor over to Simon, who will tell us what it means to be caretakers of art collections for dealers and collectors and museums on as needed basis. Welcome, Simon.
Okay, great. Thank you so much for that introduction. I am currently sitting in London, so I would say good evening, good afternoon, good morning, wherever you are. And really pleased to be asked to give some thoughts and lead, I hope, an engaged discussion about some of the issues that the art world faces, both with storage and related logistics. As many of you know, I came to the art world about 15 years ago, really from a risk management background in high value logistics, insurance, risk assessments, loss control, and also some adjusting. And I think all of that has been quite useful when we think about what Crozier and others do to provide safe custody for art in storage or in transit. What I have is a couple of slides for you to really frame the discussion. And if we can move on to the next one, I assume that most people have actually been in an art storage facility, and then I reflected on it and I thought, well, maybe not. So an art storage facility really is a location that is fairly anonymous, or most companies retain anonymity because we don't want silly people to do silly things. And what we have in these photographs is the bottom right is our facility in New Jersey called Star Ledger Plaza, if you can see that. It was originally a printing plant for the newspaper that led the market in New Jersey. The other photographs just show really corridors with art stored behind them. Some of them are collections, foundations, trusts, private collectors, and then different ways of storing art. Some are on these sliding racks, which is much more of a museum style, where curators like to look at the art on a more regular basis. In commercial art, it's pretty much the opposite. It's wrapped, it's crated, it's stored discreetly to protect it from whether it's UV, whether it's temperature fluctuations, whether it's dust, whatever it may be. So pretty boring to look at it when you think about it. We provide climate control environments. We look after physical security, electronic security, smoke detection, fire spread, all of these things, which are really the identified threats that we and others in the insurance, curatorial, conservation world would identify as being not good for an artwork. So pretty straightforward. But the one that I would highlight as being most relevant here is the location. And I'll show you a couple of photographs in a minute, when the location has not been good, when the risk assessment has not been undertaken thoroughly, you can actually introduce the type of risks that you're trying to prevent by entrusting your art to a specialist company. If we could go to the next slide, please. So here on the left, some of you may be old enough to remember 2004 and the Montmartre fire. This occurred in the east side of London, and it was a bit of a shock, not only because it had a lot of the young British artists, the YBAs, were being stored there by Mr. Saatchi, and what I'm saying is public knowledge, so there is nothing that I'm revealing out of the ordinary here. But for insurers, really didn't know about this location. And it turned out that a highly respected company in the London market had rented an overflow facility, but unfortunately, the due diligence had not been undertaken by insurers as to this facility. So adjacent to it were what I think New York's finer boroughs would call cut shops, which is where you get vehicles being cut up, tinted windows being put in, pimped up, whatever your language may be. And there were also obviously acetylene cutting equipment there, together with inflammatory materials such as paintings. So not necessarily the most desirable location to have art stored. Secondly, the smoke detection system, the fire alarm wasn't working. It wasn't connected. So when the fire broke out from one of these adjacent properties, it was over 20 minutes before somebody called the London Fire Brigade and they responded. So here were people doing the right thing, but actually the end result was not good. And it was because there was no transparency in what the art storage facility was and where it was. So lessons were learned, and I think whether it was Lloyd's underwriters, AXA Art or others, immediately took this on board. But soon afterwards, the following year, many, particularly in the US, will remember Katrina, where New Orleans was hammered by this massive hurricane. And this photograph is simply illustrative of the amount of water, surface water, that was in the city, even 2 weeks after the event. And lo and behold, one of the museums had art storage in a part of the city that was below water. And it's well documented that one of the insurers had to provide emergency response. They were bringing in evacuation teams, hundreds of thousands of sandbags, former SEALs from the US forces to help both protect and remove water from an art storage warehouse to protect the art in it. So you would think by this then lessons had been learned. If we can go on to the next slide, please. And here we have some photographs taken that I took immediately after Superstorm Sandy in New York in 2012. And lessons had been learned by some of us in the industry, not all. The photograph on the left is 20th Street in Chelsea. As the water is beginning to recede, the water level got to a height of 2 inches below that dock. Now, if you look on the far right-hand side, you will see the same Ryder truck there, and this is 18 hours after the storm has subsided. And you can see all of the materials that were deposited on the sidewalk, and in the center, you can see what it looked like the following morning. And as many of you will recall who were in New York at the time, what was in the water was certainly not pleasant and something you really didn't want to think about too much. But the interesting thing about this was that Bob Crozier had undertaken a survey with the risk assessment company a couple of years previously to understand what the risks were for this location. And RMS, as it was, advised that if there was a hurricane that hit New Jersey, and particularly Jersey, if down in Atlantic City and came up the seaboard, and it was anything of a category 3 or greater, then we were likely to suffer this type of flooding in Chelsea. So as a result, Crozier took the decision to not store any artworks on the ground floor of the facility there at 20th Street. Everything was on the second floor and above. And as a result, we suffered no loss. But the other important thing was something called splurge. These are the slosh maps that you can get, which came as a result of factoring in both hurricane force winds, wind storm in one direction, and a high tide. And as a result of that, I think the insurance industry woke up to the fact that all art storage facilities should be assessed to make sure that in these extreme conditions, they were outside of the high water mark, certainly the 100 or 200 storm mark, such that safety could be assured. And if you can go on to the next slide, please. And here, just to evidence what we faced, somebody on the left wearing a hazmat suit. This was so we could help galleries in Chelsea evacuate art from the basements, which had been used for storage. On the right, that is one such gallery after the water has started to recede. So these are the type of conditions that we face in certain geographies, and therefore the whole purpose of fine art storage is to identify risk and address it. And I apologize that this is very New York centric, but given that New York has such a preeminent position in the art world, and whatever data you look at is probably 50 or 60% of artworks are going through New York sometime in their life cycle, I think is relevant. So those are, if you can just go on one slide, what I wanted to then talk about was really the framework in which we operate. So what I tried to identify in those photographs is the physical and the reality of addressing risk. And here, this is really the legal framework that we use to do it on the flip side. So in storage in North America, we and other companies typically use a limit of liability of 60 cents a pound. It can be $1 a pound by weight. Some people, it's 1,000 pounds per consignment. But in some shape or form, all companies are trying to embody a limit of liability into their terms and conditions for storage. We look for the uniform, the UCC, to kind of give us the framework to do this. And as a result of this, we then have the warehouseman's lien, which can protect for non-payment by our clients of their storage. On the transport side, very similar. Many of you will understand COMAC and what that provides for. Yet again, in North America, we use 60 cents a pound. We have a bill of lading, which is the contract for transport. And separately, we also have another form, which is for services where we are not actually transporting the items. We are simply handling the items in somebody's residence, could be in a museum or somewhere else. But we discovered the hard way that typically a bill of lading will not protect us if we are not providing storage services. And together with our insurers at Lloyd's, we developed a new form of contract, which we use to provide that ring fence for us. In addition, when we're moving items internationally by air, other conventions and protocols come in. So that's the legal framework that we rely on. And at Crozier in North America, we have two legal forms which we typically ask clients to sign. One is the art storage agreement, and the second is an art services agreement. In Europe, we have a slightly different approach because there is really no equivalent of the Uniform Commercial Code or CARMAC. We have certain Napoleonic law in continental Europe, and in the UK, typically we rely much more on common law and case law. But I would say that the structure is very similar. In the UK, we limit liability £2 per kilo. In Switzerland, it's 2 Swiss francs per kilo. And in France, it will be €2 per kilo. So I think when we look at how we address our risk as a business, we're using this framework. And typically I'm asked always, well, that's ridiculous. You're moving paintings, you're storing paintings that are worth hundreds of thousands of pounds, millions of dollars. Why do you not accept a higher form of liability? And quite simply, over the years, and I see there are some insurance brokers on the call who can talk about this far more ably than me, but typically liability insurance is far more expensive than buying insurance for your property when you know what the value is and you know what the risks are. So if we were buying liability insurance to protect the values that we have in storage or in transit at any one time, we would have to pass those costs on to our clients, and it would be exorbitant. So it is far more cost effective for the owner of the property who knows the value, knows the conditions, and can make an informed decision to buy that insurance, and as such then agree that our liability is limited. We then have issues of subrogation, waiver of rights of subrogation, negligence. Can you contract out of gross negligence? But clearly, I'm going to leave that discussion to somebody who's far more able than I am to discuss the implications of that. So I hope that I've given you a very high-level perspective on what our business is, how we think about it, and what we do from a legal perspective. But I hope there are many questions arising from this. And on that note, I think I'll pass it across to the next speaker.
Thank you so much. And not quite so fast. There are a few questions specifically for you before we let Hanoch take over. So first of all, thank you so much. So Crozier has been around for a little bit more than 40 years. And as I understand, it started in the United States, but then it has expanded. Where you are operating, is it always the same company, or these are different companies that have connections? So in Switzerland and Europe.
So the company, the operations that we have in the United Kingdom are Crozier branded and Crozier operated, and our parent company, publicly quoted company called Iron Mountain, is effectively our banker, if you like. And we fit part of the strategy for a large global play for a company that's quoted on the New York Stock Exchange, capitalized at, I don't know, something like $6-7 billion, and operates in 65 countries globally. So we are part of their strategy to provide storage and services to these discrete markets outside of what our parent company does in the world of digital media, physical storage of documents, entertainment service, media, and collectibles, and the like. The question you also pose raises an interesting fact that our industry is very fragmented. I mean, at the last count, I could probably go to my, well, digital Rolodex and look at about 500 companies globally that do what we do. Some will probably operate one truck and a van and have half a dozen employees, up to companies the same size as we do. And that's simply because the history of the industry has been that it's been family-led in terms of individuals who've started companies, good entrepreneurs. And we're probably in a stage now where the business needs to be aggregated to get efficiency out of it. And we're behind the curve when you look at other logistics providers. You know, you can pick FedEx, DHL, Pharma, all of these other service segments, which are much more advanced than we, but we're a small industry. Typically, we would say it's about $2 billion annually for what Crozier does and all of our fellow companies. So we use agents in other markets and in other countries. And what I would say is the challenge is to work with other agents that have the same framework as us and that we can rely on to provide the same level of service. So typically we're looking at how do they contract, do they have the right insurance in place, and do they follow industry best practices?
Thank you. So you don't pass judgment on the taste of the collectors. You don't really care what they collect, be it works on paper or sculptures, or I'm curious about digital art, if you are starting to see people come to you for storing that kind of asset.
Yeah, two great questions. So the first one is, we are totally neutral on what is art to start with and what somebody's taste in art may be. And that is part of the training, that our responsibility is to maintain the integrity of the artist's intent. And occasionally that means that we have to have interesting discussions with collectors and dealers where they're trying to cut corners, which in our estimation will actually threaten the artwork, that will devalue it and affect the artist's intent. So that's our mission. We always say that we are the voice of the artwork where the artwork has no voice. But the second one is more interesting because, you know, time-based media has been around for, you know, several decades, but now we're really getting into the world of NFTs, of digital art in a very different way. And one of my colleagues talked about it very recently and said, at the end of the day, it's just an expensive screensaver, you know, just get on with life. Clearly, if there is stored value in an artwork, which is effectively what we're talking about here, and it becomes tradable in a very different way, then the assessment of risk and insurability is quite different. And the great thing for us is that because our parent company has data centers and runs data protection programs and data storage, there are solutions that we can give to our clients that we cannot provide. So whether it's frozen storage, cold storage for cryptocurrencies, for NFTs, we don't have the solution, but our parent company does. The last comment I make is the intersection of digital, art, design, architecture, fashion, music, the arts in general is really gathering apace. And we're being challenged more by that intersection in terms of different environments for storing, for example, sneakers that are traded. That is very different to looking after a lot of the artwork we've historically had in storage. New one is sports memorabilia, the ability to buy the shirt that Lionel Messi wore on Sunday afternoon and bid for it during the game, such that at the end of the game you own it, and you can then have that as an NFT. That is a new dimension to what we're facing. And I think the logical question is, are the terms and conditions under which we've historically traded appropriate and adequate for that new world? We're looking at that closely at the moment. And yet again, because we work arm in arm with the insurance industry, I think there are more challenges for insurers in establishing the true value and the true risk profile of some of these new, what I would loosely call forms of art and stored value. So it's a wide new world, and it's really engaging, and it's stirring the brain matter, which is always good for us.
Thank you, Simon. This is a really wonderful description of what assets we're talking about. Art as an asset class. That it's, for some it's normal, for some it still is a little bit chilly to think about art as anything but inspiring, divine, etc. But you're talking about storing value, and you are literally storing valuables. So thank you very much for your introduction. I'm going to turn the floor to Hanoch, and I invite everybody who is on the call to put in your questions when we do Q&A actively after Hanoch's presentation. Also, welcome to those who came in a little bit after we started. It's really nice to see Stefano here, who actually made this program possible. He was my host at Crozier, Switzerland, and it was a really lovely visit. So I'm delighted to be able to discuss art storage today in 2022. All right, so Hanoch, what can you tell us about all of the legal underpinnings where collector, museum dealer comes to an art storage manager, or comes to a realization that they can't handle everything themselves any longer? What happens?
Sure, thank you for that introduction. I can tell you that sometimes the legal framework and underpinnings can be as abstract as the art itself. And I think Simon touched on a lot of great issues contractually that we deal with as lawyers. To be clear, my firm handles not only the transactional side in advising clients on how to navigate these bills of lading and warehouse agreements and storage agreements, but also litigates the claims that arise when you have, let's say, damage to art. So I think to sort of encompass both of those, would be helpful to look at our discussion in the frame of the anatomy of a fine art claim. I know on this call we have people in various disciplines, the adjusters, the insurers, auctioneers, gallerists, etc., and everybody will be looking at, for example, a fine art claim from different perspectives, but there are overlapping themes that I want to touch on. I like to say that a picture may be worth 1,000 words, but a damaged picture can cost a whole lot more. And so it's helpful from the outset when you're dealing with fine art to have some guiding principles as you go through your business. That way, when a fine art claims emerges, you'll be better suited to navigate what happens. First, a shout out to all the insurers here. They can be your best friend in this situation. And as good as a contract may be, and as good as your records may be, operating as either a collector or a fine art store without insurance specifically for fine art coverage can be very risky. And obviously, I wouldn't recommend doing that at all. So get to know your insurance broker, and more importantly, have them really understand what it is in your collection, whether you're the one storing it or you're the one building it. Letting them know, are you collecting living artists, deceased artists? Are you storing things that are made out of food or objects that might decay? All of these things will inform insurance coverage, will inform how you navigate and draft the contract. But I do want to start with probably second to contracts. The most important issue that we deal with is record keeping. Not only what kinds of records you keep, but how to make sure that you're obtaining the right level of detail in doing so. So what you really want to try and avoid when you have a fine art claim is a factual dispute or a he said, she said. Now that's not something you can avoid every time, but the more records you have, the clearer they are, the better suited you'll be. So what am I talking about when I talking about record keeping? Of course, contracts are one of them. It's sort of surprisingly should go without saying, but doesn't, that having a fully executed contract, a properly dated contract, ones that have handwritten notations that are clear are critical. For example, we had a case in which the bill of lading was articulated properly, but wasn't signed. And so we had photographs of the art before and after. We had condition reports, but the bill of lading wasn't signed. And so there was a question as to whether the limitation of liability that Simon was talking about would really protect the fine art shipper in that instance. And so the takeaway there is you can take all the right steps, but if you don't have someone signing on the dotted line, those efforts could be in vain. Another area of record keeping you want to be thinking about is the condition of the art itself. In many situations, fine art stores do not open crating and packaging upon receipt or delivery unless they're specifically instructed to do so. So if you have instances where you're shipping things to multiple locations, to exhibitions overseas, and nobody's opened the crate in the last 2 or 3 years, and you open it up and find that it's damaged, you're going to have a very difficult time establishing what happened, when, and where. And that's the worst position to be in when you are either the person who opened it or the person who last touched it, right? So everyone would do well when they're transporting or storing artwork to have clear documentation of condition. So what does that include? Obviously, we're talking about pictures, sometimes videos, but sometimes we're talking about condition reports, incoming and outgoing condition reports. You want to make sure that those are clear and concise. You want to make sure that if you're traveling from multiple locations, that you keep a clear record of when things traveled and where they traveled. The location can matter a great deal. If you're going from an arid climate to a cold climate, knowing that and having a record of the conditions will be relevant to building out a claim or refuting one. You also want to understand, if you can, what sort of temperature and climate controls are in place. And records of that are not as easy to come by. So asking at the outset if a fine art shipper has climate control, what specifically that entails. Not all climate controlled environments are created equal. There are climate controlled shipment options that are available that you might want to consider. As many of the appraisers and conservators on the call today know, how you transition an artwork from storage to transportation to another location could create risks that you want to try and manage. So you want to be actively thinking about what's best for the artwork. And sometimes that's a conversation with the artist or the artist's estate, if that's the situation you're dealing with. but we don't want to be thinking about storing art simply as putting something in a box, setting it in a corner, and forgetting about it. At the end of the day, most of these things are living, breathing objects, if you will. Some are made of organic material, and where you store it could be critical in making sure that it survives. Another record keeping issue we want to be aware of is what the artist's technique or materials might consist of. And when I say that, I'm referring to artists that might use materials that were not intended to last indefinitely, were not archival materials. And I can think of an artist who mounted photographs with Scotch tape as opposed to archival tape. Fast forward 30 or 40 years, it wouldn't be surprising if you were to find that Scotch tape created condition issues that cannot be addressed. This is a plug for all the conservators out there to have conversations with them if you're working with older objects about proper treatment and storage and conservation if need be. But I would be remiss if I didn't talk a little bit about some of the insurance risks that we're constantly aware of and dealing with. Not everything can be protected from risk. There are some types of risks that are very costly, if not impossible to protect against. Specifically, I'm thinking about inherent vice, which is a typical exclusion in most fine art policies. And that's commonly understood as a natural instability of an artwork. For instance, if something is made of food, naturally it's not meant to last as long as stainless steel. Or, if you put an antique object in a high humidity situation, that's something that could create a risk by virtue of the material being made of organic material like wood or gesso or compo. So just because you buy a fine art insurance policy doesn't mean that everything that you own will be covered or protected. So that's a conversation you want to have with your fine art broker or insurer, with your fine art shipper or storer, your collectors. If you get nothing else out of this presentation, it's that an open dialogue about what you have, what you're trying to protect, where you want it to go with various people in different disciplines will increase the likelihood of protecting your collections. If you're trying to protect it as the storer, the insurer, or the collector, these conversations are all very important to have. And I know that the art world tends to be a bit more murky in disclosing pertinent details, but when it comes to your valuables, I think these conversations are critical to have. But probably no more important to have than anything else are your contracts. And Simon touched on the different types that we might typically see. But I want to just touch on a couple of the concepts that he mentioned, more specifically, the limitation of liability, subcontracting, waivers of subrogation, and warehouseman's liens. As a point of New York law, you can't contract out of your own gross negligence. You can protect yourself pretty extensively with standard limitations of liability. But if you're flagrant, if you're excessive, if you're completely lacking in any type of caution, most limitations of liability will have difficulty standing up in court. So that's you want to make sure to have built-in practices, regardless of which end of the deal you're on, and establish proper protocol for dealing with objects of high value and risk. Another important provision you'll see is the waiver of subrogation. Now, for those who aren't familiar with subrogation, it's those instances where an insurer might pay out a claim and seek to recover those funds that have been paid out from someone who might have been responsible for the damage. So, for example, if a collector were to put something into fine art storage and a damaged claim gets submitted, the insurer might pay the collector and seek to collect that from the fine art storage facility. One way that people are trying to avoid that risk is by including a waiver of subrogation in their contract that essentially says, in the event that an insurance claim should arise, that they can't look to us for to recover from the claim. Now, if you're the fine art store, that's a pretty important clause for you. It further limits your exposure. But if you're the collector, you want to be thinking about that with your own insurer and make sure that they're aware that that type of provision is there. The last thing you want to do is understand that the fine art store has insurance, and so don't worry, if something happens, they'll cover it. But a provision like that can really put you in a tough position. So read your contracts, read your contracts, read your contracts. The devil really is in the details. And I can't stress enough that these aren't boilerplate agreements. Some of them are pretty comprehensive in terms of the expectations for the parties. So please read them closely, consult with an attorney, consult with your insurers and your brokers. They're there to help manage these risks. And the more they know about it, the better they can handle them.
Great. So this is really a bird's eye view because we never know which parties are involved in the conversation about art storage. And there's a really good question to get us started from Emily. Thank you for posing it, saying, well, both Simon and Hanoch, you're talking about art and artists somehow being involved in storage issues, but arguably if they have sold these pieces to collectors or galleries or send them to auction houses, they have no say about the condition of the art. Does either one of you want to say anything about working with artists?
Oh yeah.
Yes, absolutely. Oh, yeah. So if you don't mind, Simon, I'll jump in. Yeah. So yes, specifically we'd be talking about the living artist, and it's always wonderful when you see art sell and collectors put them in transit or storage to wherever they may go. But the truth is, when damages arise, one of the first people we might consult with as a lawyer in determining whether an artwork can be conserved or restored, whether it's a total loss or not, is the artist. Because for those of you who are familiar with it, there's the Visual Artists' Rights Act, which is codified by the US government under the Copyright Act, which sort of enshrines a suite of protections for an artist, including the right to disclaim authorship or prevent mutilation. So those are two pretty broad topics, but to touch on it very quickly, if you don't consult the artist and you conserve something and let's say it's not conserved to the satisfaction of the artist, they can just say, you have to take my name off it. You can no longer sell it as an authentic work created by me. And so the value of that artwork could plummet, if not completely be eradicated. Sure, some people may appreciate the art on their wall regardless of authorship, but you want to be aware of that when you're handling a claim. So the artist's opinion can very much matter, and they can very, very, very much help certain conservators to understanding their methodology, their practice, the materials they use. Some materials are better than others when treating different media. So knowing what the artist used, what type of paint, what type of steel, what type of glass can go a long way to making sure conservation is successful.
Thank you. Simon, you wanted to say something?
Yeah. So I think we'd heard of VARA, but it came to really smack us straight in the face with a 4x2 after Sandy, when I think we had, and I forget the actual number, but something like 200 artworks that had been damaged from the effects of the storm, both from gallery basements, personal collections in a couple of other storage facilities that did not do so well. And we were storing them, and then it was agreed with insurers that they were a total loss. And the natural inclination is, okay, let's put them in the dumpster. Until somebody went, hold on a minute, these are living artists. We have a legal duty and responsibility to seek the artist's approval before we can destroy them. And so once we'd done our homework and together with our legal team designed a form which required either the owner or their representative to track down, either through the gallery or through the studio, the artist, to explain the circumstances, to get them to sign the release that we could legally destroy their artwork. So, as you've just heard, trying to explain that to a collector who thinks they own it, that's the end of it, is an interesting conversation. So VAR really important in everything we do in North America. The second area where it affects is also in copyright. So everybody may think that once you own the artwork, you own the copyright. Far from it. So a number of people over the years have made the mistake of certainly photographing and then using that photograph for economic return. And certainly in the case of Warhol, Picasso, and a whole lot of others, there's a whole lot of licensing that you have to go through. So simply because you own the work, that is not normally, certainly with a living or an artist that has died within the last 70 years, you still have a legal framework to navigate. So in that sense, buyer beware. Talk with a good lawyer who can navigate you through this.
I also should add that there's an important distinction to make between, let's say, a collector's desire to keep an artwork versus an artist's desire to conserve an artwork versus an insurer's desire to pay for conservation as opposed to deeming something a total loss. So the artist, if living, is an important component. So whereas, let's say, an adjuster may, based on the records, think that, and reasonably so, that an artwork is a total loss, the artist may say, well, it's still sort of in keeping with my intent. You're going to have to reconcile those differing opinions in deciding, how to proceed with the claim. So the artist isn't necessarily done once they sell. They're an important part of this process, and really one of the more important parts. Without them, we wouldn't have anything to be discussing.
Another question for the two of you is, who makes for an easier client, I suppose? So we just covered a little bit the role an artist plays. An artist, of course, depending on what they make, use art storage for their own purposes as well. But you have galleries and you have museums and you have collectors. Are there certain reputations or are there certain experiences that you can share with us? Which institutions, individuals are easier to work with, or it all depends on the works that you are tasked with protecting?
So if I can pitch in first of all, I think one of the observations is that simply because you've bought an artwork doesn't mean that it doesn't have a carry cost. So if you think about owning a car, you've got to maintain it, you've got to put gas, petrol into it, oil, it's got to be serviced once in a while. It's pretty much the same for an artwork. The time may be different, the interval may be different depending on what the artwork is, but through the life of an artwork, it's going to need some maintenance at some time, whether it's cleaning, whether it's rehanging, reframing. It can, if it's floating, it may need to just, we're talking about natural substances which age and fatigue over time. So there is a maintenance that go with it, along with the cost of insurance. And if you're lending artwork, which we encourage collectors to do, typically you can pass on some of those costs to the borrowing institution, but not always. So owning art may come with a cost that you've got to carry for the future. But I think the more interesting part of your question was, the character of the individuals. I think somebody who is a collector, who is passionate about art for their own satisfaction, rather than art as an asset and always looking at the underpinning value of a collection, is much easier to deal with. I would never be so indiscreet as to give names, but somebody who's always looking at the economic value of an artwork is potentially more difficult to deal with than somebody who is looking at it from their personal appreciation or from an altruistic perspective of it being good for society. So I don't want to be too judgmental. I mean, I'm challenged by that with my daughters pretty much every week. But the art world is made up a lot of different personas. And in our industry, we talk about complex art and complex collectors. And it's navigating a whole world there. And that's what makes it interesting. I'll be quite honest. If it was all the same flat discussion every day of the week, life would be pretty boring. So art encourages people to be expansive, to be creative, and their personalities reflect that. So, having a good understanding of the psyche is probably 101 to be in our world.
Thank you. Hanoch, do you want to talk about maybe training? Which participants in the art market are more ready to agree to certain conditions about art storage, and which ones tend to be more surprised by some of the elements?
Sure. First, I should say I love all my clients. And I would never seek to disparage any of them. Some highly sophisticated clients in certain spaces actually have worse record-keeping practices than some others. If you own one artwork, you may have all the possible details in the world. If you have 100,000 objects, yes, the expectation that everything is documented very clearly is less of a reasonable expectation. But I think most of the insurers, the adjusters, the conservators, the appraisers, they all have some exposure to these limitations and liability. And I think we all recognize that the handling of art is a very physical process, and there are a lot of risks, regardless of age and type and media, that without protection from complete exposure, it really wouldn't make much sense to insure the art, to ship the art, to conserve the art, and in some instances to appraise the art. So I think knowing that you're operating in a high risk area is very important, and I think most people recognize that. I think one thing that people, to be perfectly honest, I've seen a lot of are less knowledgeable about is the need specifically for people who have specialty in fine art. It's one thing to have insurance, it's quite another to have fine art insurance. It's one thing to use a common carrier like FedEx or UPS versus someone who specifically handles fine art. And same with storage. We unfortunately have seen a number of situations where people use common box storage, and one of the very first things that it says in those contracts is we exclude and waive liability and decline liability for any valuables, collectibles, fine art. And so it kind of gives me pause. Why are you storing your gallery's inventory in one of those places that doesn't provide you adequate coverage, and certainly isn't taking into consideration climate control and those sorts of things? And I've seen far too many times people sending valuables through FedEx or UPS or DHL, not to disparage any of those carriers. They do fantastic jobs, but their limitations of liability are as broad as you might expect, because they often don't know what it is that they're carrying.
Thank you. There's a question about, there are two questions about types of art that is being stored. So one is, can ordinary artists, not just superstars, afford the kind of art storage we're talking about? And the other question is, are there works of art so complicated or unrealistic to store that maybe, Simon, you have refused to take something big? Let's say it's a banana on the wall, but there you're not really storing the banana, it's the certificate. So do you turn away collectors, artists, clients for any reason?
Over the years, we have. I'm trying to think. Mainly where the risk associated with it is going to endanger other artworks. I remember we had one that was, you can take it from one extreme to the other, but it was a large birthday cake that was simply in a cardboard box. And we looked at it and we went, well, this is just what rodents love to come and nibble on. So we kind of went, we then developed a framework that we don't accept flora and fauna unless it's under certain conditions, and then we can dig into it. So if you imagine, a lot of Damien Hirst artwork over the years, we've had to deal with dead flies, butterflies, you know, that you get into CITES and other things. But those are all encased, so they're fine. I think it's where our challenge becomes size. It's less the material. You know, it's the Richard Serra installations of this world that actually give us the biggest issue, because our facilities are normally designed for, you know, flatworks or small 3D, you know, standard Jeff Koons, no problem. But when it gets to Serra, we're really talking industrial scale there. You know, it's being moved on barges and low loaders, and that's more a true logistic exercise than an art exercise. So it happens once in a while, but I can't think of any over the last 5 or 6 years that we've had an issue with, to be honest. Yeah.
Just to circle back to something I discussed before, you know, the issue of things that insurers are usually do not want to cover are things like inherent vice, and certainly things that are pre-existing or the result of gradual deterioration or wear and tear. And so one tool that can be pretty helpful is in advance, especially of a major exhibition or a major transit or consignment, is to work with appraisers. You want to make sure you have something that is recent. If you have an appraisal, and to recognize that appraisals are done for various reasons, for estate tax purposes, for retail replacement. So to have something in hand that you can point to, if, for instance, there's a total loss like a fire or a flood, that would establish some kind of value before you enter into these complex projects. But we talk about all these things and it sounds costly and expensive. There are mechanisms, and there are people at various scales. Simon mentioned that there are operations that are more modest and lean, and there are costs that, even let's say at an operation like Crozier, like you have general storage versus private storage that is specifically acclimatized. I mean, there's a broad range of services that companies like Crozier and others would provide, and I think it's not necessarily cost prohibitive for emerging artists or artists that come from more modest means. So I wouldn't foreclose on those completely, but insurance is also, if you can't afford, let's say, fine art storage, there are other ways to avoid risk through contract that you might want to consider.
Thank you. So as I'm going to do a little plug. So as you may know, or many of you know, the center is doing a number of clinics. One of them is a clinic for artists planning their legacy and for estate planning purposes. And many of the artists and their heirs who come to us, they say, what do we do with art that we have? How do we store it? So for artists waiting to be discovered, or artists that really are not necessarily in the news every time Christie of Sotheby's has a sale, what kind of advice can you give them? Is there any kind of storage, not percent for the arts, but when there's a fantastic building being built in Manhattan, there's maybe a little bit of space preserved for lower income dwellers. Is there something like that in the works in the top echelons of art storage?
I would say, I think we have a range of storage and storage rights. I think with particular regard to artists, we're looking at how to provide a package for artists that may not be able to afford full storage as it is today, or get to art fairs, and come up with something which really engages with the artist who's at an early stages of the career. They may be old artists, but they may be at the early stage of their career. Because I think what we believe is that that's part of our responsibility to the art ecosystem, that we can't just provide for high net worth, ultra high net worth galleries, Sotheby's, etc., like that. We have to engage at different levels. So we're actually working on that at the moment, and it gives us an opportunity to also bring in some of the sustainability measures that we're introducing, whether it's in storage, whether it's in shipping, whether it's in the consumables we use. So there's a whole engagement going on both internally give a plug for the Gallery Carbon Coalition, which is really doing a super job in raising that agenda in the commercial art world. I think the next 12 months, you're going to see a lot of different programs coming in with us, with the auction houses, leading galleries, and ultimately with collectors who need to engage and be part of this discussion. So it's, I would say, no simple answers today, but a whole lot of ideas that are being pushed around. And I think we'll see some real progress in the next 12 months. It's quite exciting.
Thank you. I know that we're at the end of our presentation, and Simon, you actually covered one of the questions we had about sustainability, what kind of new materials being used. And I wonder if sustainability can be, or will be at some point, part of a contract where collectors ask for a particular type of.
Well, I'll tell you, we're already seeing it in museum RFPs. So when we're asked to respond for museum bids, that is now part of the scoring criteria for a number of museums. I would say more in Europe at the moment, but beginning to see it in the US as well. So that is most definitely a way of keeping everybody honest.
Thank you. There was a question about coverage and storage for digital art. I know, Simon, you mentioned that your parent company can provide assistance where you, the curator, are not yet specialized in digital art storage. But what about insurance? I know this is a little bit outside of our sphere. It's kind of touching on the series we're doing called Some Like It Digital. So maybe we should talk about the practicalities of collecting digital art. Is there a special insurance that has been created in the last, I don't know, 6 to 12 months?
I read an article last week. I mean, we've got others on the call who are on the, I see in the post, you're probably better to answer it. All I would say is I read an article last week saying that it is a challenge and there is no real product specifically for the art world at the moment. You've got to rely on other cyber related products, digital products. It's not addressing the question. It's just trying to build a framework until somebody has that spark of imagination to come up with something.
Yeah, I'd have to agree with Simon. I mean, there are cyber insurance policies, and much like someone who has a fine art policy might also have a policy to protect their building, a policy to protect them from liability from others. Sometimes a robust insurance portfolio is something you may want to have, but just like maybe there isn't a specific insurance landscape for the digital art, the legal landscape is also evolving. So if you were to ask any number of questions about NFTs, and I could look to, copyright or trademark or trade dress issues, I probably would have to include the caveat that, the legal framework is often playing catch up to the real world. We can only litigate, we can only legislate at one fixed point in time. We don't necessarily know how things will change, and so there sometimes has to be flexibility with the lawyer's typical answer that it depends, right? Because most things don't have a clear-cut answer.
Thank you. On this note, I'm going to thank both of our presenters very much for their time and expertise. The subject is not as dry or as hospital-like as some might have expected while looking at the pictures of just cases and shelves dealing with art storage. There are definitely lots of nuances, and I hope we're learning from each other to avoid any pitfalls that 2012 brought back and 2005. Special thanks to Minelli and our team that has worked on this event. And we are looking forward to your feedback, everyone. If there are specific topics you would like us to discuss or guests you would like to hear from, let us know. We are very pleased to announce that we have new board members and advisors joining us in 2022. There are lots of events in the works, lots of topics to discuss, and I am personally looking forward to seeing many of you both in Zoom and in person this year. So happy New Year and come back whenever you can.